issues with your neighbors in regards to where your boundary is and where their boundary lies isn't always resolved purely by survey. You may be in a situation where you or your predecessor has been getting along with the neighbor for many, many years. You thought you knew where the property line was. Somebody new buys the property or maybe inherits the property of your neighbor. They do a survey and they tell you that your pool is on their property line, or they tell you that your garage is on the property line, or a good portion of your backyard or front yard is on the property line, and they're saying that now you have to move it and they want to put up a fence. There are a variety of claims that are out there that will establish title even if the survey says that the legal title was properly in the name of your neighbor. There's something called adverse possession. Adverse possession is a statute and a process upon which you go to court with what's called a petition for quiet title, and in that situation you show that for 20 years you've continuously adversely held the property, and you've done it such with uninterrupted use, and you've basically done it in such a way that the other side should have known that you were claiming ownership of the property, and it was without permission from the other party. Now what that means is that you don't have to be sitting there with an axe handle saying don't come on this property. It's you're taking actions that are acting like this is your exclusive property, and you can do that even with both of you thinking that that's where the property line is. I had a case that went up to the Supreme Court where the trial court agreed with me that the property line was for a variety of years. Both sides thought that this was where the property line was. The other person, nice neighbor, sold the property to somebody else. The other person was not so nice, got a survey and made a claim that the boundary was much more closer to my client's house, and trying to take a claim for that, take their garden and take the variety of the issues. But what I was able to establish was for 20 years, there was acknowledgement of where the property line was, and also where the adversity there of us continuously to operate under that presumption. So we were able to establish that we actually had possession. There can actually be also, for getting title that's beyond a survey, boundary line by agreement, which means that both sides agree that this is where the property line is. And what that matters, and also what the other previous case I was talking about matters, is you don't consider just the two existing neighbors, you consider their predecessors. So anybody that's in the chain of title, with chain of title mean that owned that property before, what they did matters. So if you have 20 years of the previous neighbor or the person before them total combined, and then this new neighbor comes in and thinks they can do a survey and change up that, they can't. So you can establish that in court, and you can actually establish by adverse possession or boundary line by agreement if the people agreed where the boundary line was. And that happens sometimes with lake properties. I see a fair amount where people have agreed that this is where the beach of their shared beach is, this is where their line is. That can be established. There can also be something called a boundary title by estoppel, when somebody's taken some action and the other side's detrimentally relied. They say this is where the property line is. This may not even be the 20 years issue here of establishing by 20 years. They actually show this is where the property is. Maybe they put a bench there that made it very clear that that's where they thought the boundary was, and the other person bought the property thinking that's where their beach right was. That might be a boundary that might be title by estoppel. So there's a variety of actions that can happen that change the survey. Surveyors sometimes will just say this is where the property line is, and they're very clear that that's their established line because that's what the legal title shows and where they found the marks. That's not necessarily the case, and it's well worth it in some of these properties to fight that and establish truly where the boundary is by quiet title action. You can do that in the courts. You get in front of a judge, basically in front of it, and you explain where the title is. And again, it happens a lot with lakefront properties and other properties where there's some value there. Certainly somebody wanting to take their swimming pool away or their driveway away is worth the fight.